Let's go into like the workers' comp aspect. Like when something like this happens at work, a lot of people, either really do want to file a claim and get the workers' comp, or kind of really don't want to, like, really sue their business, because that's what you're doing, right?
Yes.
But it doesn't have to necessarily be a suit. I mean, as long as workers' comp is set up for a reason, and I'm going to defer to Brian on a lot of this because he has a lot more knowledge base in the workers' comp arena, but it is a system that has been set up to make it easier for the employee to have a right of recovery when they're hurt on the job.
In theory, that's true. As the statute's written out, that is true. But Florida, well, actually, Florida is different than a lot of other states. Kind of contrast it with Alabama. But state of Florida, it's an administrative system, so you actually wouldn't go to the traditional courthouse and litigate your case through the traditional civil litigation suit process like you do in Alabama. In Alabama, you actually file a civil lawsuit against your employer, and their workers' compensation insurance carrier pays for the defense. Not dissimilar than it is when you have a car crash and you sue the person who hit you, and their insurance company comes in and pays for the defense. But it's an administrative system, and theoretically it's built for speed. You automatically get your health care, you get benefits while you're off work, and things like that. As far as a slip and trip, even if you have one of those on the job, it's still a good idea to talk to a personal injury attorney. Sometimes attorneys that do workers' comp do the personal injury slips, trips, and falls kind of things too. Sometimes they don't. A lot of times we can investigate the claim, and we can determine that, okay, maybe it was an outside party, not your employer, because under Florida workers' compensation law, you cannot sue your employer outside of workers' compensation. So even if they do something unreasonable and leave, water on a floorway or oil on the floorway or whatever it is, and you slip, you trip, and you fall, you still cannot sue them other than for your workers' compensation benefits. A lot of times, though, we get involved, and our investigation shows that they had a third party that was actually responsible for that. Maybe it's a cleaning service. Maybe I've got a case right now that it was a garage, and they brought in an outside company to pressure wash all of the fleet vehicles inside where they do the fleet maintenance, and they left all this water on the floor and the mats, and it caused one of the employees of the maintenance company to fall and injure themselves. He has a workers' compensation claim against his employer. He also has a personal injury claim against that service that came in to do the pressure washing, because they did not perform their duties safely. They didn't perform them reasonably by leaving that much surface water where they did. They're supposed to squeegee it all off and make it safe for the employees walk on. So you can have both. They're not mutually exclusive, and that's something that your attorney needs to flesh out pretty seriously. I did a lot of workers' compensation when I was practicing in Alabama in the first 15 years, and I did a lot of third party suits that arose out of those. So.